Is it an exhibit, by the way?
It is an exhibit. It's 244.
Okay.
It lists the various reasons why. It lists the various reasons why the case was dismissed against the 3 lacrosse players.
By the AG's office.
By the AG's office. That where Mr. Nifong obviously had to recuse himself at that point because he had a conflict, but he did turn over all of his documentation, was very cooperative with the AG's office.
Indeed.
And I don't mean to get distracted, but while we're on that point, you asked a number of questions about shortly after the Crystal Mangum situation when she had the subsequent interview with Linwood Wilson, why did he just dismiss the one charge? And I would contend during that period of time is when he's also receiving all the state bar information, and that's sort of when he didn't need to be making any further determinations about whether to go forward with the case or not, because I would contend he had a...
Get back to your point, but I mean, it was after he got the letter of notice as to the DNA complaint that he made the decision that he did to dismiss it in part.
He made the decision based upon the report he got from Linwood Wilson.
Yes, but it was after he got... If your argument, though, is at that point he was not making any charging or major decisions about the conduct of the case because he knew he was going to have to recuse himself. He had already received the letter of notice.
That's correct, and he probably I would contend he probably shouldn't have dismissed the charge at that point. I think once he had that letter of notice, he needed to get out of the case and shouldn't be making any decisions because any decisions he made, as you are doing now, could be viewed as suspect. Just like if he had dismissed, I'm sure if he had dismissed all the charges in January after receiving the complaint, all we would have heard about was how he dismissed the charges because he got the state bar.
Well, my only point is he did do something. He did that half measure of dismissing dismissing the rape charges after he got the letter of notice of the DNA. Don't want to get stuck on that.
Actually, let me get back to my point.
Yes,
on Exhibit 244 on page 20, the AG lists a number of reasons why the charges were dismissed. Said they received multiple and significant inconsistent, and again, which Mr. Nifong endorsed as soon as this report was done, and issued a letter of apology the very next day to the determination to dismiss the charges. They list a number of things: inconsistencies, no DNA evidence confirmed her stories, no medical evidence confirmed her stories, no other witness confirmed her stories. The accusing witness's account of the story changed significantly. Nothing in here says, and DNA was found on her rape test kit indicate other people committed the offense. I mean, the AG's office basically doesn't even address it in their reasons why they dismissed. That's how much they thought of that evidence. And to say that evidence was so important that Mr. Nifong would throw everything away, I think you can consider in terms of what his intent would be. And I think you can look at the particular facts of this case to realize he's aware of his statutory obligations. He's aware of what can be found. The why question I was going to ask, and I'm sure you have some answers, why would...
You're going to ask me a question.
I'm finally going to answer your question. I mean, why would he throw his whole career away on something and continually lie to the court where he'd always shared an excellent reputation on something that is going to be discovered and has to be discovered by statute?
Well, first off, you have an assumption in that question that it is going to be discovered, and I would disagree with that. But even accepting your premise that someone looking at that would have to conclude that it would be discovered, I think there's a mistake that we make in criminal cases and in cases before the DHC. For instance, in DHC cases, we see all the time conduct by attorneys that is not explainable as being rational in any way that we would understand. So I think we kind of need to acknowledge that sometimes people do things for which there is no rational explanation, and we don't have to have. You ask that question in hindsight. Of course. Why would he do that? Of course. Well, the answer is, I don't know. I don't think we'll ever know. But that is true of people who, after 30 years, take clients' money. Why, and we ask ourselves that question all the time, why does somebody risk their law license and indeed a criminal conviction by doing something so stupid as to take money from their trust account, which is almost immediately and irrefutably established? I don't know. I never know. So, but I mean, it's a good question, but I don't think it's a question that we have to have a rational answer for.
But generally, when you're doing something like that, there's a clear indication that you can't go in and steal. And clearly we know we can't go in and lie as well. But there's no indication at all to know. People take money a lot of times from trust account because they have exclusive control over that trust account, and they may believe, having represented, well, I won't do a test. A number of attorneys who take, I would contend, who take money from trust accounts do so with the thought that they will never get caught, that they'll put the money back in, that there's no way to catch them because they'll balance things out, and I'll take a little now, next month I'm going to have a good month, I'm going to put it back in. And then generally, generally when the people get caught is when they continue to do it and it spirals out of control and they take so much money there's never a way to put it back in. And that's what leads to discovery, not the initial taking, but the eventual takings, and then the trust account is generally out of whack. You generally don't see somebody who comes in here for the first time hoping they won't get caught. In this case, it's clear it's going to come out. There's no way these defense lawyers in this case are not going to discover that, and Mr. Nifong knows that on May 12th.
I disagree with that premise.
Well, you know, you're the trier of fact.
We are. Yes, we are.
I would just contend that under the facts of this case, if I was talking about a pure hypothetical, I may agree with you, and if I was talking about unrepresented clients, I may agree with you. But I contend to you, with the expertise that was on the defense on this side, that Mr. Nifong is not going to try and intentionally hide something from them. And then, and again, keep in mind, he's the one who gave it to him under a court order, but he's the one who gave it to him. He's not taking any further. If he's already, at this point, he's already staked him. So your other argument would be he would expect that when he turns the documents over to this defense team, that they're not going to discover it. Not thinking they're going to...
They almost did.
Well, but there was mention of experts in some of the prior hearings. Mr. Bannon specifically says we need to get certain things over to our experts. There have been experts mentioned beforehand. Mr. Kingsbury says we specifically want to look for this. Language you keep referring to on 922, he says we want to look for this. So under your theory, if Mr. Nifong is hiding this, he already knows on 922 this is specifically what they're looking for, and there's been mention of experts as well. And somehow he's going to slide this under this defense team and their experts and them not discover it. He makes no attempt to try and pull out those electropherograms or try and have any... At this point, under your theory, he's purposely lying.
Well, don't call it my theory. I'm playing devil's advocate with you, which was one of those publications that apparently talked to. I don't know what.
I won't say your theory. Under that theory, I don't mean to attribute anything to you that's not yours. But under that theory, he's held himself out to the judge. He's been lying. He knows he's withholding something. All of a sudden, he knows he's busted. And then he knows they're looking for it, and he knows there's experts out there, and he makes no attempt to cover his tracks and say, here, just turn it over, and then just put Dr. Meehan up there to testify as to what he knew and when he knew it. No attempt at all to cover what he had done.
I would say that doing nothing but turning over 1,844 pages and throwing Dr. Meehan, Mr. Obfuscation up there on the witness stand, that's doing something. That's running away and throwing candy behind you and hoping they'll pick it up. No, that's an interpretation.
I mean, this is an individual at this point who's had 5 or 6 motions to compel discovery against him. Everything he does, there's a motion filed on, so it's not like he's just going to be able to throw it away and it goes away.